Well, good afternoon, everybody. Welcome to the joint Marsh and HFW claims webinar that we have for you this afternoon, tackling the latest COVID-19 updates and litigation developments. And my name is Tim Scott-Young. I'm the Australian Claims Operations Manager for Marsh. And today we'll be hosting a second webinar session. For those of you who may recall, we did hold a very similar session about 6 months ago now, back in November of last year, around the status of the UK and Australian test cases. And as many of you will be aware, there have been significant developments in the last 6 months. And I'm joined by Sophie Woodward and Richard Jewett from HFW Lawyers to assist in navigating our way through those changes and the impact that it can potentially have on our BI business interruption claims that you may have. I'm also very fortunate to be joined by Luke Stratford, who heads up our Claims Solutions team for the Pacific, and he will have a couple of words to say towards the end of the webinar around how our advocacy and forensic teams can also assist. So what are we going to be covering today? Well, I'll generally just make some introductory comments around some COVID claim numbers that Marsh are seeing across the Pacific, and then we'll let Sophie and Richard take you through the Australian and UK positions around the UK test cases and the Australian test cases. And then Luke will have some very helpful hints and practical tips as what to expect and how to lodge claim notifications with underwriters. We'll have some time for questions at the end. So we have received a couple of questions already, but feel free to click on the Q&A button and then we'll take those questions on notice. If we don't get to all of them, or some of them require a detailed response, we promise to get back to you personally back to each of you who submits a question with a detailed response for you. Usual disclaimer around sort of the content of this presentation, general interest only. Obviously, if you need specific legal advice, please feel free to reach out separately. So, without further ado, Pacific COVID claims update. So, to date, we've received a total of 756 claims that have been notified across the region. Majority of them won't come as a surprise, relate to travel claims, but there's about 20% that we've received in relation to property, BI and ISR claims. Now, of those, there's been about a little bit more than a third have been denied by carriers and underwriters. So we've received 68 declinatures to date. And most of those really have occurred in the first sort of 6 months post-COVID in sort of March to September last year. So most of the underwriters that we're seeing today are really sort of putting their responses on hold, obviously pending litigation outcomes. And we really haven't seen any sort of denials come through in the last three to 4 months. Most of the COVID notifications that Marsh have received have come from two underwriters, and Allianz and Chubb. Now, Sophie and Richard will take us through some of the issues in securing cover for our COVID-related BI claims. So I'm just to spend a couple of moments on introducing them to you all. So Richard is Insurance and Reinsurance Practice Head of AFW in Australia. He's been instructed to act in relation to many major insurance events in Australia and around the world, including various bushfire class actions, the Wivenhoe Dam and Brisbane floods class action, the Tianjin explosion in China, and on various insurance issues from cyclones in Queensland and coal mine floods. My favourite is that he's in fact been instructed to advise in relation to a collision between a merchant shipping vessel and a Los Angeles class nuclear attack submarine off the coast of Bahrain. And I wonder who survived that outcome. Sophie specialises in complex disputes, particularly contested insurance claims. She has 15 years experience in the field and has acted in numerous high-profile claims, including the class action litigation arising from the World Trade cleanup operations, the Newcrest class action and associated D&O claim, and are currently a large insurance claim arising from the failure of paint and insulation on an LNG facility. So without further ado, I'll hand across to Richard, who will take us through the first part of the presentation for you this afternoon. Thank you, Richard.
Thank you very much indeed, Tim, for that kind introduction. And Sophie and I are both delighted to be participating in this Marsh webinar today. Just to sort of go through the points that we're going to cover, I'm going to take you through an update on the Financial Conduct Authority test case appeal. There was a judgment handed down in January this year, and it covers a wide-ranging series of matters that are potentially of relevance in Australia as well, and we'll talk a little bit about how those may impact the Australian courts. Sophie's going to give you an update on the first test case involving the Quarantine Act, and then also a brief summary of what's happening in relation to the second test case, which has just been commenced but won't be heard for some time yet. And then, of course, Luke and the Marsh team will be taking you through some matters about how to prepare and submit claims. And, of course, we'll have time for questions at the end. So next slide. Thank you, Tim. Okay, well, look, what I thought would be useful just to give the background, and I know a number of the attendees here have been involved in some of the earlier seminars that HFW have been involved in, but others haven't. There are sort of like 5 broad areas which are going to be have been the focus of COVID claims. The first of these is the question of whether there is property damage, and as we all know, the standard trigger for the vanilla cover of business interruption is property damage, and that means you need to have some kind of physical damage to the insured property itself. This is kind of a dead duck now, I think, in terms of COVID. I think it's generally accepted that COVID as a virus doesn't really cause property damage. And if it did cause property damage by being on the surface or getting into someone's air conditioning system, it's very short-lived outside the human body. And therefore, any business interruption that would be consequent upon that would be very short indeed. So the focus is much more shift to what I describe as the non-damage extensions. And these are extensions that appear in a number of ISR policies, and there's 3 in particular that I'll be talking about in a little bit more detail. The first of these is disease cover, the second is prevention of access, and the third are hybrid clauses. And as I said, I'll give you a quick summary of what those are later in the talk. The third issue is causation, and I've also tantalizingly raised the question of wide area damage. Obviously, with any type of business interruption claim, there needs to be a connection between the damage or the trigger and the loss that's been suffered. In the vanilla coverage, there's a double causation test. The double causation test involves considering whether the consequential loss is resulting from a business interruption, and the business interruption needs, of course, to be consequent on the physical damage. Now, in the extension, sometimes that causation test is reduced down to a single causation test. In the more complicated types of extension, such as some of the forms of prevention of access, there are multiple triggers that need to be met sequentially. So it always depends upon the policy wording, but essentially causation is going to be an important feature here. And there's been some very interesting developments in the Supreme Court action in the UK, which I'll be talking about, as to how causation should be applied in relation to pandemic type of events. The next point that's obviously been a focus both in the FCA but also generally is a thing called the trends clause. Now, all business interruption policies tend to have a trends clause or an adjustment clause. For those of you who understand business interruption insurance and have been involved in the past, essentially it involves looking at 2 things. One looks at the actual turnover that the business has sustained in the period, and that is obviously usually affected by whatever the loss that has occurred has happened. Then you compare that to the hypothetical or counterfactual turnover, which is often labelled as standard turnover. You take the difference between the 2 of them, multiply them by the rate of gross profit, and that produces your loss. Now, what the trends clause does, it allows alterations to be made to any of those elements, the standard turnover, the actual turnover, or the rate of gross profits, so as to take account of special circumstances which would have affected the business anyway. And that is even if the damage hadn't occurred. Now, that trends clause has been subject to some commentary by the Supreme Court. And again, I'll be talking about that in a little bit more detail. And then the final area, of course, is exclusions. So if we now move on. Just to give you some background behind the FCA case, this is the Financial Conduct Authority, which is the regulator in the UK. What had happened is shortly after COVID first broke out in England, a number of claims, I think around 300,000 claims were lodged with insurers, 60 or 70 insurers in the UK. And a lot of the insurers started taking very literal and specific approaches to their wordings and denied claims. And as a result, there was certainly some unrest that occurred in the market, and the FCA took it on itself to have a discussion with a number of insurers and said, look, these issues haven't been dealt with directly in the context of an event as wide-reaching as the pandemic that we're experiencing, and it'd be very sensible for everybody to get together and to have a test case put through the courts at high speed so that we can get some of these issues agitated in a constructive fashion and get some rulings from the court on key questions so that there's going to be greater certainty. So it's a really useful process where, interestingly, insureds, representatives of the regulator and representatives of certain policyholder groups and insurers all got together in a fashion so as to seek clarity on some of the issues that were being thrown up by the different policy wordings. The FCA selected 21 sample wordings and 8 major insurers were involved in the proceedings and 2 policyholder groups. The judgment in that, I think, has already been the subject of an earlier webinar by Marsh, perhaps the one in December. That was given on the 15th of September. It's a very comprehensive judgment, 150 pages by 2 very reputable High Court judges. If we flip on to the next slide. The High Court accepted many of the FCA's arguments as to the effect of the sample wording, but didn't agree with everything that the FCA had suggested should be the position. So the FCA has appealed that, or did appeal that judgment. Also, 6 of the insurers who are unhappy with the results of the High Court judgment also appealed. Now, rather than going to the Court of Appeal, which is the normal second tier appeal court from the High Court, and I should just comment here that it's a little bit different in Australia. We have Supreme Courts, which are our first entry-level court, and then we have a Court of Appeal, which is in the Supreme Courts, and then we go to our High Court, which is our highest Court of Appeal. In England, it's slightly different. They have the High Court first, then they go to a Court of Appeal, and then they have the Supreme Court, which used to be called the House of Lords, which is the ultimate Court of Appeal. Now, in order to get resolution, they skipped the Court of Appeal completely and went straight to the Supreme Court. And the Supreme Court had a very condensed hearing as well of these issues, and almost unheard of, handed down a judgment a few months later in January this year. And again, another very comprehensive judgment. I'm not going to talk about the detail of that judgment in this talk. There's lots of very subtle nuances and clever reasoning and arguments that were addressed, but I'm going to try and give you a snapshot of the key points that came out of it and what those actually mean in terms of parties or policyholders who have any of these particular extensions and clauses in their policies. So the key issues we considered were the disease clauses, the prevention of access and hybrid clauses, causation, and then the trends clause and the correct counterfactual, which is what I've mentioned already, and in particular 2 issues they looked at, which were pre-trigger losses and the Orient Express Hotels judgment, which is a judgment which prior to the pandemic had been the only English authority on how the trends clause operates. And interestingly, it's been reversed. Anyway, we'll discuss that in a little bit more detail shortly. If we move on to the next slide. What I wanted to do here was to assist in providing context as to 3 of these clauses that have been the focus of the FCA's attention. The first is the disease clause, and in general, there are obviously variations of these types of extensions. Each insurer doesn't necessarily have the same extension as other insurers, and some of them also have exclusions built into them. But generally, they provide cover for business interruption losses which result from an occurrence of a notifiable disease within a specified distance of the business premises. So it might be a radius of 25 miles or 25 kilometres or some other distance. The prevention of access clauses, extensions, they operate to provide cover of business interruption losses which resulted from a public authority intervention. So when a government authority, for example, introduces lockdown measures, which either prevent or hinder access to the business premises. And then we have hybrid clauses, which are sometimes a combination of these two types of clauses, which may have elements of both of them. And as I said, there's a vast range of these clauses in the market. And if you are the beneficiary of a policy which has any of these in it, you should be looking very closely at them to see whether you've got a basis for presenting the claim, particularly in light of the FCA judgment. Now, the Supreme Court held in relation to disease clauses that what they do is they respond to BI losses resulting from cases of disease which occur within the specified local radius. They don't respond to cases of disease which are outside of that local radius. So that's kind of a logical approach to it. Slightly different to the way the High Court looked at it, but I think the important thing is the Supreme Court has said, yes, look, it's a question of, are you within the radius or not? There needs to be an occurrence within that local radius of the disease, and then you've prima facie got a trigger for your cover. Now, what they then went on to do is they looked at the causation question, and the court spent a lot of time looking at causation and considering all the competing types of tests. It's a very interesting analysis of proximate cause and the different types of causation tests. They eventually concluded that the but-for test was not the appropriate test for ascertaining causation in an event such as this. And they said that actually what can happen when you've got a pandemic event like this, you've got concurrent causes happening, which have led to the government's response, which is to introduce measures that interfere with people's businesses. And those concurrent causes are all of the cases that happen nationwide. Now, one cause is obviously the events that happen within the radius. Other causes happen externally. And what the court said is that because you've got concurrent causes operating here, and because nothing is actually excluded outside the radius, and if the policy had been intended to exclude cases outside the radius, they could have said that. Because those are not excluded, those are also operative. And then all of them contribute to the actions by the public authorities and the governments in introducing lockdown measures. So where you get to is that if you have a local occurrence or breakout of the disease within that radius, then providing that has happened prior to the lockdowns being put in place, then you've got a basis for making a claim for the entirety potentially of the loss that you've suffered. It's not an instance where simply the case of the disease within the specified radius may not have been enough on their own to cause the interruption. You can have the recovery through the fact that you've just simply suffered a case within your radius. Moving on to the next slide. The prevention of access and hybrid clauses. Again, these were construed quite broadly to allow for expansive cover. So when they were looking at the question of restrictions imposed, these included the government's instructions regardless of whether they'd actually been incorporated yet into legislation and regulations. So that's an important aspect of considering how things work in the order of events. In relation to an inability to use premises, so this isn't particularly in the context of prevention of access, the insurers were arguing that there has to be a complete prevention of access. The court said, no, that's not the case. That's not, one should look at this in a commercial way, the way a policyholder understands the policy to operate, and said that in circumstances where the premises have been partially interfered with, so if they're a restaurant, for example, if they're prevented from having sit-down patrons attending the restaurant, but they can still carry on takeaway business, that is still an inability to use the premises in the sense that they can't have the sit-down patrons, and that's enough to be able to trigger the clause and therefore give rise to a claim for a business interruption and losses that flow from that, connected with that inability to use the whole of the premises. So that's an important aspect of prevention of access. These issues are actually going to be agitated in the second test case in Australia, which Sophie will be touching upon later in the talk. Moving on to the next slide. I've talked about causation already, so I'm going to jump straight into the trends clause. Now, as I've said, the typical trends clause provides for special circumstances or business trends affecting your business, which would have happened either before or after, that would have been achieved even if the damage hadn't occurred. Now, a lot of the focus on this particular clause in the past has been in those final words, if the damage had not occurred. And they've said that, well, look, what you've got to look at here is the actual damage that occurred. And that means if it's an insured premises or something that's happened in the insured premises, that is the focus of it. Now, the court looked at the arguments that were being raised by the insurers concerning this clause and said, look, this is not an exclusion clause. It's there to assist with the quantification of the loss, and it shouldn't be read as an exclusion clause. And when quantifying it, it cannot be applied to any circumstances having the same originating cause as the insured peril. So they actually looked behind the damage and said, what has caused the damage? If what has caused the damage is an originating cause, which is the effect of the insured peril, the pandemic, then that is not something that should be taken into account to adjust the claims down. Now, there is another case which was considered at the first instance judgment, but not addressed in the appeal judgment at all. It's a Hong Kong case involving Orient Express Hotels and an unpronounceable Italian insurance company, Generali, which involved SARS. And in that particular case, there was a notifiable disease, and the insurers successfully argued, both at first instance and in the Court of Appeal in Hong Kong, that everything that happened before that notifiable listed disease was registered as a notifiable disease was not something that could be taken into account because of the trends clause. And the Supreme Court in England has not followed that. They've said actually that's the wrong approach, and they've said that what you can do is anything that's connected with the pandemic, which has led to the damage, is something that can't be taken into account. And so therefore, the whole of the loss that the policyholders has suffered is something that should be recoverable. So moving on. It follows from that the wider effects of the pandemic are not things that can be factored into quantification of loss once the cover has been triggered. And so therefore adjustments should only be made to reflect circumstances which are affecting the business which are entirely unconnected to the pandemic. So something which would have happened anyway, fluctuations in commodity prices, if that is, they're going to happen in any event, even outside of the pandemic. Now, that's overruled the Orient Express Hotels judgment, which, as I said, is the only English authority. That was a 2010 judgment. Interestingly, it was an appeal from an arbitration award, and the arbitration award had on the panel a QC called Mr. Leggett, who actually was one of the Supreme Court judges who gave the judgment contrary to his original views in the arbitration. And also the judge who heard the appeal from that arbitration in the original Orient Express judgment, Hamblin, was also on the Supreme Court. And both of those judges have resiled from the views they expressed at that time and have reversed Orient Express Hotels, saying that it's not good law. And again, saying that really one should look at the originating cause as being the relevant aspect when one is considering how a trends clause should operate. So it's a very significant development in business interruption law. I think there's going to have wider ranging implications for lots of other business interruption cases as well, not ones just that arise from pandemics, because for many years the insurers have been looking to the trends clause and seeking to make adjustments, which they will be less able to do now, bearing in mind it's been given a much wider scope as to how it should be interpreted. So moving on, I think it is now going to be Sophie's turn. So I'll pass over to Sophie to talk about the Australian cases.
Thanks, Richard. So I'm going to be going through the status of some of the test cases that are on foot in Australia. And I think what should be clear to everyone is that we are unfortunately quite a long way behind the UK. We're still quite a way from having a lot of these key issues determined in Australia. And part of the reason for that is that the first case that was brought in Australia was very narrow in scope. The insurers in that first test case were hoping that a lot of claims could be knocked out by the determination of the single question as to whether exclusion clauses that refer to quarantinable diseases applied to COVID-19 in circumstances where quarantinable diseases was a concept that was used under a repealed piece of legislation called the Quarantine Act. Now, unfortunately, for insurers, that test case was not successful. And so we're still in a position in Australia where there are a lot of unanswered questions which are still working their way through the courts. So I won't spend much time on this first test case because I understand that it was the subject of the update that you all received last year. But just to recap on what the outcome of that first test case was, it concerned the interpretation of the exclusion clause, which you'll see up there on the slide. And the exclusion clause was in relation to circumstances involving, relevantly, diseases declared to be quarantinable diseases under the Australian Quarantine Act 1908. Now, in 2016, that act was repealed and replaced with the Biosecurity Act 2015. And when COVID-19 first occurred in Australia at the beginning of 2020, it was declared to be a listed human disease under the Biosecurity Act and not a quarantinable disease under the repealed legislation. Now, the New South Wales Court of Appeal unanimously found that the exclusion clause did not apply to COVID-19 and that you cannot take a reference to the Australian Quarantine Act to be a reference to the Biosecurity Act. Insurers in December last year filed an appeal to the High Court against that decision. And if you just flip to the next slide, I'll give you a quick update on where we are with that appeal process. So the High Court has said that they will hear oral arguments in relation to the appeal in May or June at the earliest this year. So a date has not yet been set, but it is approaching. The way that appeals to the High Court work are that the High Court both determines whether they're going to grant leave to hear the appeal in the first place, and then also give their decision as to whether the appeal should be granted or not. So whether the original decision of the New South Wales Court of Appeal should stand or whether it should not stand. So it looks like the matter should be finally determined when the High Court hears that case. Of course, it will take a few months at least for it to hand down its decision. So we are some way away from having a final decision on that issue. The grounds of the appeal that have been put forward by the insurers are really can be summarised in two main arguments. The first argument is that the reference in the exclusion clause to amendments to the Quarantine Act should also be taken as encompassing the repeal and replacement of that act with equivalent legislation. So a similar argument was put forward really before the New South Wales Court of Appeal, but the insurers have referred to other authorities that weren't specifically referred to by the New South Wales Court of Appeal and which support, the insurers say, the position that the reference to an amendment can also be taken as a reference to a repeal and replacement. The insurers have also put forward somewhat of a novel argument. They've said that a principle of statutory interpretation, which is that you can give provisions an ambulatory construction. What that means is that when a particular piece of legislation is enacted, if factual circumstances develop over time, then you have to apply the original reference in the piece of legislation to the factual circumstances that exist at the time. And so in this case, they say if you are referring to a piece of legislation which has been replaced by a new piece of legislation, then you apply the reference to the old legislation as if it were a reference to new legislation. Now, that's a principle of statutory construction. It's never been interpreted as something which applies to interpreting contracts. So it seems unlikely that it'll be accepted. It is a novel argument. The second key argument that insurers have put forward is that the test that the New South Wales Court of Appeal applied when they were considering whether to, in effect, sort of rectify the reference to the Quarantine Act, which was that you had to show that the parties to the insurance policy knew about the correct state of affairs and just made a mistake in not referring to the correct state of affairs, in this case, the correct piece of legislation. The insurers have said that was the wrong test. Instead, what the New South Wales Court of Appeal should have done is, as a matter of construction, look at the literal words of the contract and consider whether they give effect to the real intention of the parties to the contract. And in this case, it was quite clear that the real intention of the insured and the policyholder was to exclude business interruption losses caused by a disease which is so serious that the Commonwealth imposes quarantine restrictions. Now, unsurprisingly, the policyholders' response to that in their reply to the application, to the appeal application, is that you can't assume that the real intention of the parties to the insurance policy was to refer to the Biosecurity Act. Here, there are still a number of diseases which are quarantinable diseases under the Quarantine Act, and it was quite possible that the parties intended to refer to those diseases. So it remains to be seen what the High Court's decision will be. If I was a betting person, I would say that it seems unlikely that they will overturn the decision of the New South Wales Court of Appeal. But that, it is not, we can't be certain that that will be the outcome. What is certain is that the outcome is going to be quite significant. So there was an affidavit filed by the CEO of the Insurance Council of Australia with the application for leave to appeal. And in that affidavit, he said that the ICA estimates that 250,000 insurance policies have this Quarantine Act reference in them, which is quite extraordinary, really, and that there is potentially $10 billion worth of losses that will fall to insurers if this case is determined against them. Now, that submission obviously ignores the fact that even if this exclusion clause is found not to apply, policyholders still need to get over that first hurdle of showing that the policy has been triggered, which is really the subject of the second test case. So we move on to the next slide. It's also relevant to note that there's another test case that has been filed in Victoria by QBE. This also concerns the application of an exclusion clause that refers to the Quarantine Act. Now, what QBE are arguing in this test case is that for policies that are subject to the law of Victoria, the court needs to take account of Section 61A of the Property Law Act in Victoria. Now, I've put the wording of that section up on the slide, but you'll see that what it says is that where an act is repealed and reenacted, then unless a contrary intention expressly appears, any reference in any relevantly contract to the repealed act or provisions shall be construed as a reference to the reenacted act or provision. Now, the application of that section of the Property Law Act was not considered by the New South Wales Court of Appeal because there's no equivalent piece of legislation in New South Wales that says the same thing. The New South Wales Court of Appeal did consider a similarly worded section of the Acts Interpretation Act that also said that a repeal and reenactment should be construed as a reference to the original piece of legislation, but that section of the Acts Interpretation Act only applied to statute and not to contracts. So it is possible that this test case could be successful, in which case you'll have an outcome where insurance policies that have Quarantine Act exclusion clauses that are subject to Victorian law will be in a different predicament to those which are subject to the laws of other states and territories. If we go to the next slide, I also wanted to talk about the case of Vanilla Lounge versus Vero. This is quite an important test case that was heard in December last year by Allsop in the federal court. Allsop seems to be hearing all of these test cases, so I'm sure he's extremely busy. This test case concerned the breadth which courts should give to the application of exclusion clauses that refer to the Biosecurity Act. So these exclusion clauses obviously don't have the same problem that exclusion clauses referring to the Quarantine Act have, because they refer to the current piece of legislation, and COVID-19 was declared to be a listed human disease under the Biosecurity Act. So in this test case, Vanilla Lounge, which was a bar and restaurant in Victoria, brought a claim against Vero. Now, the main claim is yet to be determined, but the court was asked to determine as a separate question the application of this particular Biosecurity Act exclusion clause. Now, you'll see the wording of the exclusion clause on the slide, but a few things to note about it are, first of all, the introductory wording of the exclusion clause is very broad. So it says we will not pay any claim that is directly or indirectly caused by or arises from or is in consequence of or contributed by. Now, Allsop noted the breadth of that introductory sentence, and he said that he was minded to give the exclusion clause a broader application because of the wording. And it may be that a differently worded exclusion clause could have a more narrow interpretation. So, you need to pay very careful attention to the drafting of these particular clauses. The second thing to note about this exclusion clause is that it's triggered by a biosecurity emergency or human biosecurity emergency declared under the Biosecurity Act. So it's not triggered just by a listed human disease under the Biosecurity Act. Rather, the way that the Biosecurity Act works is that after a disease becomes a listed human disease under the Biosecurity Act, a second measure that is available to the federal government under the Biosecurity Act is that the listed human disease can then be declared to be a biosecurity emergency. And that's in circumstances where there is a significant threat to human health, and it's necessary to implement, for example, border controls. So the court considered how broadly this exclusion clause should be interpreted. Unsurprisingly, the insurers argued for a broad application of the clause. And so what they said is that as soon as you have a disease that's declared to be a listed human disease under the Biosecurity Act, this exclusion clause is triggered, and any claims based on BI losses resulting from that particular disease are not covered. The policyholders argued for a much more narrow application, and they argued that you needed to have a declaration of a biosecurity emergency or a human biosecurity emergency. And then you also needed to have measures imposed by the federal government under their powers that they had under the Biosecurity Act in respect of biosecurity emergencies. Now, if that interpretation had have been accepted, then the exclusion clause would have very limited application, because it's a particular feature of the response to COVID-19 in Australia that all of the orders that have been made restricting human movement and access to premises have been made by state governments rather than the federal government. So the Biosecurity Act has actually been used in practice very little in Australia. The court found somewhere in the middle of these two interpretations, and what they said was, as soon as you have a declaration of a biosecurity emergency or a human biosecurity emergency, then all measures taken by any governments, state or federal, in response to that emergency are excluded under this exclusion clause. Now that case is still moving through the courts. Vanilla Lounge seemed comfortable that that particular decision did not mean that it could still pursue its claim. So I'll be watching that case with interest. Now I'm conscious of time. I think I'll just cover one more slide so that Luke's got time to present his part of the presentation. Let's flip through this slide. This just sets out some dates when key events have occurred. But if we go to the next slide, I'm going to briefly touch on the test case, the second test case in Australia. So this is a much more broad test case, and it covers, a large number of policies and a large number of points of law. The 9 claims that are the subject of this test case were specifically selected from amongst a range of different business sectors and also locations throughout Australia. The issues that are being considered are very similar to the issues that were considered in the UK test case. A particular issue which is being considered is, the government measures that were announced and whether these amounted to a response to an outbreak of disease within a particular radius of the relevant premises. What I might do is just briefly talk about one of the test cases that is being considered. Now, this concerns an Allianz policy, so it may be relevant to some of the policies that are held by Marsh clients. So this was a policy issued to a clothing store in Adelaide. They had to shut their premises after certain measures were taken by the South Australian government in response to COVID-19. Their particular policy had both a disease extension that was triggered by an outbreak of a notifiable infectious or contagious disease occurring within 20 kilometres, and also a prevention of access clause, which was triggered by a measure taken by a public authority to restrict access as a result of a threat of damage to persons or properties within a 50-kilometre radius. Now, that reference to a threat of damage to persons or properties is found in a lot of Australian policies, and was not issued in policies that were under the consideration of the UK Supreme Court, as far as I can see. So that's quite a novel Australian policy wording, which will be considered in this second test case. So the policyholder in this test case has argued that because they were able to point to a occurrence of COVID-19 at a particular individual tested positive at Adelaide Airport, which was 6.88 k's from their premises. Therefore, that was enough to trigger both of those extension clauses. So you'll see that the outcome of those types of claims are likely to be relevant to a lot of claims that are on foot in Australia at the moment. Now, I'm out of time, so I might let Luke continue on from here.
Thanks, Sophie. I appreciate the opportunity to speak with everyone today. I just wanted to provide a little bit of an update in regard to claim solutions and how we can support our clients. The claim solution team is a combined advocacy and forensic accounting group. Okay, we're a single point of contact, and we've got real bench strength. We're made up of chartered accountants, CPAs, lawyers, and also engineers. We're here to support you through the claims journey, and our experience is really in delivering the largest and most complex losses. Thanks, Tim. How can we help you? How can we support you? We're here to really help you understand your policy and to help you assist your claims appropriately. Help you to notify insurers of a potential claim whilst the legal framework that we've been talking about today is being resolved. We analyse facts and the policy as the claim evolves and advise on maximising your coverage opportunity and navigating the frameworks that insurers and loss adjusters are likely to rely upon as they try and process literally thousands of claims. We provide guidance on dealing with information requests, including advice on whether insurers' requests are reasonable. And it's likely that insurers will require claimants to provide factual information about how COVID-19 has impacted them. Avoiding information paralysis is going to be very important. We then negotiate on your behalf with insurers to achieve an expedited and cost-effective resolution by leveraging relationships and minimising external legal costs associated in many instances with things like coverage limits. Thanks, Tim. The forensic accounting team is here to help you communicate your financial loss due to COVID to insurers. We understand numbers and we know how to align your financial loss with the coverage provided under the policy. Our forensic team can assist you to communicate your financial loss as a result of COVID-19, provide what-if analysis to help you understand how to maximise your claim and manage expectations, prepare high-level loss estimates to accompany notifications and in your endeavour to seek indemnity, and formulate detailed claim submissions when the time is right, including financial loss modelling, alignment with policy requirements, preparation of causation matrices to support your claim, linkage between financial loss to causation, and alignment of financial losses based on heads of cover. Thanks, Tim. So in summary, due to the large numbers of claims that insurers and loss adjusters are likely to need to deal with, it's going to be quite important that you get the right support. The models that insurers and loss adjusters are likely to rely upon may not fit your specific circumstances. It's likely that you will need assistance to maximise your recovery. Once indemnity and coverage is confirmed through this legal process, there is still a need to address a number of issues, and insureds are likely to need assistance to respond to proposed adjustments and frameworks. The Claims Solutions practice is here to support you, our Marsh clients. We're here to work with you and the Marsh team to maximise your recovery and expedite the claims resolution process. Thanks, Tim.
Thanks, Luke. Well, look, let's just take a moment to reflect on three very impressive presentations. All of them very detailed, and I think it just really goes to show just how complex this area has become. And I think back to where we were in September, October of last year, and the UK test case had just been delivered. And that was really only the beginning of the journey. And we all thought, following the first test case in Australia, that it would be resolved. And then, obviously, a number of complex issues arose firstly out of the UK and the position we had to proceed on, and then obviously that led to the second test case in Australia. So probably an hour in a webinar for this type of complex discussion is really only scratching the surface. So very important to all our clients that you reach out to your Marsh broker for advice, to Marsh Claims Solutions and our advocates, and also to HFW in relation to legal advice if you think that there's some complexity of issues that you need to work through. So in conclusion, some practical steps. I mean, what have we heard this morning, this afternoon? First of all, do you think you've suffered? Do you think your business has suffered a loss due to COVID? Has there been a downturn in revenue? If so, let's have a really good look at your policy. Look at the insuring clauses. Look at the relevant extensions that may apply. Obviously, the exclusions, the limits, and the sub-limits. And all this is about seeking guidance if you're unsure. And that's where Marsh can assist in providing you with that type of advice and next steps. Then we have to look at the relevant facts around the particular circumstances, looking at nearby outbreaks at locations if it's particularly relevant to an exclusion under your policy, looking at the government orders and any decisions that have been made in the area, when they were made and how they impacted your business. I think most important of all, it's really looking at ensuring that we retain details of your financial losses. As you can see, this is a long process. Sophie indicated that at the very earliest that decision may be received in or heard in May or June. It may be 2 or 3 months before a decision is handed down by the High Court. So this, as you can see, is certainly stretching out through 2021 and will certainly encroach into next year as well. So as time passes, you know, it's really important that you retain all that financial information that the insurer will require to determine the claim and the response to coverage. So in short, consult with Marsh, please. Very important that we notify insurers of a possibility of a claim. Do not fail to notify. It is a moving feast at the moment. It is complex. There is uncertainty as to how policies respond. So it's very, very important that there is no assumptions made at this point. If there is a possibility of a claim because of a loss of revenue in your business, then let's help you advise the insurers, your insurer accordingly. Really important to gauge with Luke and my team in relation to the claim and helping you file that with the underwriter. And then obviously if there's issues in relation to coverage or dispute, that we can retain and refer to external coverage counsel where appropriate. So they're our sort of key points for you this afternoon. We're doing very nicely in terms of timing. We do have a number of questions which have been provided to us. So I'll throw to the panel, so to speak, and certainly if you'd like to obviously send through a question, please do so on the Q&A. If we don't get to it today, we'll certainly respond to it very quickly. So Sophie, the first question for you, you're first off the rank. And I'll read it out to you, how likely is it that the federal court in the second test case will follow the UK Supreme Court decisions and any guidance that they'll be providing?
I think it is likely. So we already have examples in other common law jurisdictions like South Africa, where the courts have been, persuaded to follow the same reasoning as the UK Supreme Court and the UK High Court. It's not a sure thing, though, that will be the case in Australia. On the broader issues such as causation and the application of trends clauses, it does seem likely that the reasoning in the UK Supreme Court will at least be very persuasive on an Australian court. That being said, the policy wordings that are issued in Australia, while they vary as between each other, they also do seem to vary in some respects from those policies that are typically issued in the UK. So there are going to be some differences. And then also, of course, the circumstances in Australia where we have lower numbers of confirmed cases and also, very different legislative responses, including measures taken by state rather than federal government, will be, will almost certainly produce some different outcomes.
Okay, thank you. Richard, I've got one for you. I'll put you on the spot here. Someone's written in, I have a disease extension clause in my policy. Do I also need to show an instance of COVID occurring in any particular geographic radius? And then a second part of the question, will my claim be limited to losses only from those cases within that radius? What are your thoughts on that?
Well, this issue has still not been addressed by the Australian courts yet. There's two questions there, but I can give you, if the Australian courts were to follow the English court approach, of course, it depends upon the wording of the extension, but I think for the first question, if you've got a case, an outbreak or a case of the disease within the radius, then that should be sufficient to trigger the policy extension. So you get past first base if you can do that. The the second question, and this is an argument that the insurers are, have always loved to run in Australia, is, oh well, even if you do that, are you stuck just with the losses that that have arisen from that from the cases that have occurred within the radius? Now, this is where, if the Australian courts follow the English courts on here and say, look, there's concurrent losses here, and you've got to take account of the much wider effect of the pandemic. And my money would be to say that the Australian courts should do that, but there's obviously no certainty. Sometimes Australian courts, want to show their differences by taking a different view to the English courts. But if they do follow the English courts, then the person who's got this particular policy shouldn't be limited by just what happens in the radius. They could be able to say, well, look, if the lockdowns, because of what's happened at a wider level, we should be able to recover. So I'd encourage that particular policyholder to have a good look at their policy, consult with Marsh, check things through, but definitely advance the claim.
Okay, terrific. Look, I've got one online that came through at the start of the webinar. Were there any themes in relation to the denials thus far, especially interested in regards to BI claims? Well, look, I'm happy to take that one. I think that's coming from Craig. Look, Craig, from where I'm sitting, you saw on that first slide, there was about 140 odd BI claims that Marsh have received to date. Of those, about 41 have been declined. Now, of those 41, there was probably about 25% that was specifically related to the Quarantine Act exclusion. And the rest, I think, were a little bit far more wider ranging in terms of not only the Quarantine Act of 1908, but also in relation to prevention of access and other heads of declinature. So what we saw in relation to those 25%, where it was just a sole exclusion, obviously a great outcome and great result following that first test case. But the insurers obviously haven't yet reversed those original decisions, so they're still sticking with them. Obviously, the matter is subject to appeal. They don't intend to alter their views or opinions until that appeal is finally determined by the High Court. So I think Sophie mentioned that if she was a betting woman, that she would be saying that the High Court would be dismissing the appeal. If that's the case, then certainly those cases will get up and be successful. But there is obviously, 75% of our other declinatures within BI that are still being considered under other heads of declinature and subject to that second test case. So thank you, great question. And we'll have one last question, I think, which we took on notice from before. Sophie, I'll throw to you. You've got 60 seconds to respond to this one quickly before we close. But if a policy has a Biosecurity Act exclusion clause, is it likely that claims based on COVID will be excluded?
I should be able to answer that in 60 seconds. The answer is it depends. I think what was clear from that Vanilla Lounge and Vero decision is that the court is going to look very carefully at the drafting of the particular clause and also the circumstances of the particular business interruption losses and whether they followed orders of the federal or state government and whether they followed certain measures taken by the federal government under the Biosecurity Act. The claim by Vanilla Lounge against Vero is still ongoing, so they clearly consider that their exclusion clause doesn't exclude their claim. So I think, certainly don't accept any decision of an insurer to decline a claim on that basis at face value, and you should be interrogating your policy a bit further.
Excellent. Well done. 59 seconds. So look, that brings the webinar to a close, everybody. As we mentioned at the beginning, we'll certainly be making available these slides for everyone who registered, as well as a recording. If there are other colleagues that you think may be interested, that will certainly also be available. So thank you for Sophie and Richard in terms of making your time available this afternoon. We appreciate your insight and skills, and Luke, thank you for your time. So thank you everyone else on the call for attending, and take care and have a great day. Thank you.
Thanks everybody.
Tim.
Thank you.